Well, everybody, we got a bunch of filings. Uh, this is the Pacer site where I obtained the documents. These are going in reverse. Filed today, we got sealed exhibits 3, 4, 5, and they're not available on this site because they're sealed. Basically, Colborn was requesting to get all the news footage that the producers of Netflix, Laura Cardigan or Demos, used to in their documentary. So they're trying to obtain all the info from the attorneys without having to pay for it like they had to when they got it from the news places. But $2.99 was the last one I did. Or 300 motion restrict documents, but I'm gonna go through each one of these. So let's see. This is only 2 pages, so this one only cost me 20 cents. Unopposed civil expending motion to leave exceed page limits. Plaintiff undersigned counsel respectfully moves the court for leave to exceed the page limits. Brief opposition motion summary judgment pursuant to civil local rule. Yada yada yada. Due to the factual complexity of this case, defendants sought and received leave to exceed the page limits and were ultimately granted leave to file briefs up to 45 pages each, rather than local rules usually limit to 30 pages. Plaintiff did not oppose the motions. Plaintiff intends to respond sufficiently to possible as the respective motions, but without leave to include additional pages, he would likely have to omit or severally duplicate discussion of important points that are necessary for him to address a response to the defendant's motions. Despite some similar themes, defendant's motions include distinct arguments as to how legal principles are asserted to apply as to respective defendants. Distinct discussions, the legal authority, and distinct treatment, additional factual. And download that real quick, so I gotta pay for it again. Go back. This one, I said that was 301, so we'll go to 302. Document restricted, can't be found. So, yeah, that's what I figured. 303, clarified text only order. This is just 2 pages. Plaintiff unassigned counsel respectfully moves the court to clarification of the October 26, 22 text order, permitting him to exceed the page limits in response to the defendant's 2 respective summary judgment motions, to clarify that he may submit combined response to both motions in support of the motion. Plaintiff states as follows. The court granted the plaintiff prior motion to exceed page limits otherwise applicable by local rule, granting the plaintiff 45 pages. Plaintiff is in the process of editing his response. The defendant's motions, while in final discussion, decision has not been made. The combined response to address both the defendant's motion strongly being considered as it may look logical, easier to read to follow the court and parties. Defendant's counsel had previously indicated they did not object to a motion to leave file response, brief for 45 pages, and plaintiff response. Separately, each defendant's brief to file a combined brief up to 90 pages. Plaintiff counsel apologized to the court for his prior motion confusion regarding the issue. All right. Four. Motion granted. If he chooses, plaintiff may submit one combined response to both pending motions for summary judgment. The combined response may exceed 30 pages limit. Blah yada. A motion to restrict document as the video evidence by plaintiffs. See the restricted document. I doubt I'll be able to get to see it. Maybe. Oh, 2 pages. Place motion template restrict as a video evidence. Pursuant to Rule 5.2D of Federal Rules and Civil Procedure Civil Rule, plaintiff by undersigned counsel respectfully moves the court to restrict from public access video evidence contained in a removable drive that is being submitted separately to the court by courier for delivery tomorrow, November 4th, until the court decides merits of the certain defendant's motion to restrict access to such materials. In support of his motion, plaintiff states as follows. Defendants Crow Media, Laura Cardium, or Demos have filed a motion to restrict access to raw footage of Stephen Avery's trial, claiming that there is good cause to do so. Yes, because removable drive that is arriving by courier, part of plaintiff's response to defendant's summary judgment motion, contains Chrome footage of the Avery trial. Plaintiff has opposed Chrome's motion, document 298, but plaintiff requests that the court accept the material under seal until it decided merits Chrome's motion. Which one was that? That's 305. So 306, letter from attorney George Burnett to clerk with flash drives containing exhibits. 307, brief from the opposition filed by Netflix Incorporated, motion to partial summary judgment. Let's see what this is. 20 pages, so $2. Okay, plaintiff Andrew Colborn's motion for partial summary judgment must be denied. Colborn fails to set forth the standards he must meet to be entitled to summary judgment, ignores and denies that he has been burden of proof, and does not explain how the scant evidence he cites actually supports judgment in his favor. Instead, Colborn misstates much of the law and facts. He also advises the court that no matter the outcome of the motion, he intends to present to the jury some unspecified number of other purportedly defamatory statements, video footage, graphics, and perhaps even music. Colborn's refusal to narrow the issues in the case, even when asking summary judgment, continues. Colborn's MPSJ lists 52 of what he calls statements or embezzlements, many which are, on their face, not about him. He does not explain how these 52 disparate pieces of the 10-hour Making a Murder series of false defamatory, indeed, many of them are indisputably true, and Colborn now introduces new theory into the case as it ages well into its 4th year, defamation by implication. But he does not explain how any of these 52 statements support the purportedly defamatory implication that he either planted evidence and framed Stephen Avery for the murder of Teresa Halbach or participated in a broader conspiracy to do so. Meanwhile, he ignores 7th Circuit case law on defamation by innuendo, apparently believing that he can prove a defamatory implication just by saying it exists. And he makes no attempt to actually prove as the burden to the implication he imagines is false. Only proposed fact he prefers is supportive of the claim that he did not plant evidence in his own. Self-serving denial. If that were sufficient to grant jury judgment in his favor, there could be no documentaries of any disputed issue without liability. Finally, he ignores the heightened burden he faces as a public official to prove that Netflix released MAM with constitutional actual malice. Colborn's MPSJ must be denied. To obtain summary judgment on a defamation claim, a plaintiff must present evidence to prove that a defendant published false, defamatory, unprivileged statement. As a conceded public official, Colborn must also prove by clear and convincing evidence that Netflix distributed MAM with a consistently mandated level of fault. Actual malice, meaning publishing a false statement of fact knowingly or without degree of awareness of its probable falsity. This is an exceeding height burden, and despite exhaustive search, counsel for Netflix was unable to find a single decision from the 7th Circuit or any federal or state court in Wisconsin in which a public figure plaintiff like Colborn successfully moved forward summary judgment on the issue of actual malice against the media defendant like Netflix. Certainly, Colborn has not cited any such case from the jurisdiction or any other. In any event, Colborn does not cite record evidence that would meet his burden of proof and any of the 5 elements he must prove. Other than publication of MAM, which Netflix has never disputed, he does not even acknowledge he hides the burden he faces under the First Amendment, or frankly, that he has burden of all. Colborn so badly misstates defamation law that a ruling in his favor would turn decades of settlement proceedings on its head. Colborn ignores or upends the burden he faces summary judgment. Colborn completely ignores and thus does not begin to satisfy the standards he must meet under Federal Rule of Civil Procedure 56, where, as here, the movement as a burden proof of the claim which in moving the summary judgment he must lay out elements of the claim, cite the facts which he believes satisfies the elements, and demonstrate why the record is so one-sided as to rule out the prospect of finding a favor in the non-movement on the claim. Colborn does not do that. Instead, he either misstates or ignores the standards that he, not Netflix, must meet to prevail at disputed elements of the defamation claim. Colborn misstates his burden to prove falsity. Colborn fundamentally mistakes the burden of proof of falsity, claiming the defendants have burden of proof, truth, and PSJ at 5th, 16. He could not be more wrong. Colborn, not defendants, must prove that MAM conveyed false statements on a fact about him to reasonable viewers. Since he never acknowledged that he's a burden of proof falsity, Colborn has never acknowledged his burden to prove material falsity, and the statements would have different and more damaging effect in the mind of a reasonable viewer than the press's truth. He also describes that statements of variable fact can be false, opinion, speculation, and hyperbole are not actionable defamation, nor questions, theories, and conjectures. I'm going to stop right here because he's never watched the documentary. So how does he know what's in it? He's always said he's only watched a few episodes up until season or episode 7, but he's trying to sue for $20 million. So that's all 20 episodes for both seasons. Now we all know that Brenda Schuler, the one that's helping him make Convicting, is the one that convinced him to take on his lawsuit. And by pointing of dozens of scattered snippets to MAM, he ignores the settled law that such statements must be analyzed in the context of MAM as a whole to assess his new and misguided claim that the snippets somehow imply, as incontrovertible fact, the participating in the evidence-planting conspiracy. Taken together, these settled principles mean that Colborn must prove that a reasonable viewer, considering the challenge statements in the context of the entire 10-hour span of MAM, will understand that MAM, or most specifically Netflix, to be making affirmative statements of a defamatory fact about Colborn. In other words, Colborn must cite record evidence conclusively demonstrating that the reasonable viewers would understand MAM and Netflix to be adopting or endorsing Avery's accusations and presenting that those accusations as fact, even though they can constitute just one of the several inherently conflicting viewpoints that the series documents in the telling the story of Avery's trial, where his accusations were obviously hotly disputed. Assuming he can clear the hurdle, he cannot. Colborn must then prove those accusations to be false. Netflix does not have to prove that any of the 52 statements Colborn points to is true, though many of them are. Netflix also does not have to prove Avery's innocence or that Colborn planted evidence to ensure Avery's conviction for Halbach's murder. Rather, for Colborn to succeed in establishing defamation by implication of the innuendo, he must affirmatively prove that alleged implication is false. He must prove that he did not plant evidence to ensure Avery's conviction. He does not grapple with this at all. Colborn ignores his burden of innuendo and other elements. Colborn, new theory of defamation by implication by innuendo requires yet another showing, assuming the court even permits him to introduce this never before pleaded theory of liability years into the case under clear Seventh Circuit precedent. To establish defamation by innuendo, Colborn must prove by clear and convincing evidence that Netflix intended or at least knew the reasonable viewers would understand MAM itself to be drawing conclusions about Colborn's culpability. He cannot do that. Instead, Colborn argues that his requirement does not exist. Beyond the proof of falsity, Colborn also has the burden as to each challenge statement as well as overarching alleged implication. To prove that each statement implication is about or concerning him that is not privileged and that the defamatory in the sense that it subjects him, not someone else, to public hatred, contempt, or activism. Colborn disregards his heightened burden of actual malice. Finally, Colborn discards the extraordinary burden he faces in public official regarding actual malice. Colborn must prove by clear and convincing evidence that Netflix distributed M&M knowing that each of the challenge statements alleged implications about Colborn were false or being highly aware probable false. On summary judgment, Colborn must set forth undisputed material facts that would support a reasonable jury's finding of actual malice by clear and convincing evidence. Noting the plaintiff required proof, clearly convincingly that the defendant fact entertained serious doubts in the publication's truth. This burden is by design and daunting one, and obviously demands significant time and attention. Yet the phrase "clear and convincing evidence" is now aware to the found by Colborn's NPSJ, nor does Colborn even attempt to tie any of the purported evidence of actual malice pulled from the three discrete sets of notes Netflix provided to the proofs of the defendants to any of the 52 statements he puts in his issued motion or the alleged evidence planting implication. Colborn does not even bother to define actual malice means or address the fact that his burden to prove it. Colborn cannot prove the challenge statements or the alleged implications are actionable. Even if Colborn had properly acknowledged the relevant standards, Colborn and PSJ fails because the facts that he fourth fail to satisfy his burden to prove that portions of the MAM he challenges are actionable as defamation. Studying alone, not one of the 52 challenge statements is actionable because not one is a false statement of fact about Colborn. More than a third of Colborn's MPSA consists of 52-item chart, which he calls statements of MAM establishments, and Colborn does not present evidence showing that one of the 52 statements is false. As a result of his failure to even attempt to show falsity, the court should, and dismiss each of the 52 statements as non-actionable without further analysis. Nevertheless, for the court's convention's sake and completeness, Netflix attaches an appendix here to summarizing multiple reasons why each 52 of the non-actionable reasons include statements. Now, hopefully in these next documents, there'll be these 52 statements he's speaking of, because they're just numbering them. Statements 5, 8, 10, 12, 15, 17, 21, 23, 24, 26, 43, 47, 52 are not even statements. They are descriptions of video images, graphics, and still photos displayed in MAM. Okay. Statements 4, 6, 7, 11, 14, 16, 18, 25, 27, 28, 30, 31, 35, 42, 45, 8, 48, 50, 54. There's 54. I thought there was only 52. So now there's 54. Are not statements of fact. Rather, they must consist of contain either unverifiable speculation of conjecture and statements of hyperbole of speaker's opinion, therefore are not actionable. Statements 8, 10, 12, 15, 19, 21, 23, 24, 43, and now there's 52. Okay, 52. Extended construed as statements of verifiable fact and true, substantially true. Statements 3, 4, 11, 29 through 30, 31, 33, 34, 36, 54 are not about Colborn. Statements 39, 41, 44, 48, 50 are substantially identical to the statements made by Avery's murder trial and therefore not actionable because they're based on privileged facts. Colborn's description of statements 15, 21, 25, 26, 27, 30, 33, 37, 39, 42, 45, 46, 50, 54 are uncomfortable, misleading, and lack proper context. The majority of the entries in Colborn's chart are substantially impermeable to claims that he did not even mention them in the body of the SAC regarding relegating them instead of Exhibit A and failing even now explain how they are false or inflammatory despite his burden to do so. Take Statement 3 as an example. To meet his burden to show the statement is false, Colborn would need to prove that the Manitowoc County Sheriff's Office did not have evidence in 1985 that Avery was innocent, or that someone in the Sheriff's Office did not say something about the lack of evidence against Avery. Colborn has no such evidence. Likewise, with regard to the Statement 4, he would need to prove that Manitowoc County was prepared to hand Avery $36 million. Again, Colborn has no such evidence. Well, he was suing Vogel and Kucerik independently for $18 million each. Or no. Yeah. Well, you know what I'm saying. Collectively, 52 challenge statements now support Colborn's new inimitable level of theory. Regardless, it does not prove the alleged implication false, except explaining why he believes that each of the 52 items is materially false. Colborn asserts in sweeping terms that they collectively imply or institute the plaintiff of a group of law enforcement officers that include the planted evidence from frame Stephen Avery for murder, and he claims that implicable is false. His proof, he says didn't do it. There are many problems with the argument beyond the fact that Colborn did not actually plead to a defamation implication claim on any of these three iterations of the complaint. First, as the appendix demonstrates, the vast majority of the 52 statements simply do not say what Colborn claims. That Colborn planted evidence, for example, statements 3 through 29 and 38 cannot be reasonably interpreted in accusing Colborn of planting evidence in the Halbach case because they're exclusively about jail call he received in around 95, the misconduct surrounding Avery wrongful conviction 1985. But the thing is, though, he goes on and says that, they don't make reports about phone calls. Then why in hell, Mr. Colborn, are you filing a report about you receiving the phone call the day after Stephen Avery is released from prison? If you don't make reports about phone calls. So, I believe Mr. Colborn did his job and passed the information on to somebody, and that's as far as it went, because it got all the way back to Kucerik. Everybody in Manitowoc County and the goddamn sheriff's department, the county, the city knows who the fuck Stephen Avery is. So, yeah. At most, these statements go to possibly that Colborn had motive to frame Avery, which is true, and allowing Avery to accuse Colborn and just one other officer, James Lake, of evidence planted as part of Avery's defense of Halbach's murder. Judge Patrick Willis found no matter of law that Colborn did indeed have such motive. Regardless, a statement that a person has motive to commit wrongdoing is not a statement accusing that person of actually committing wrongdoing. Second, Colborn does not address the burden to show that, considering the documentary in full and challenge statements in context, MAM actually conveyed a reasonable viewer that, a matter of incontrovertible fact, Colborn planted evidence to frame Avery for Halbach's murder or conspired to do so. MAM does not make any such assertion. It simply reflects the fact that such allegations were made by Avery and his defense counsel, then reiterated the relevant supporters in controversial Halbach murder case. Third, to prove defamation by implication, Colborn has to prove by clear and convincing evidence that Netflix intended for viewers to understand MAM by asserting incontrovertible fact that Colborn planted or conspired to plant evidence, or at least knew the reasonable viewers might interpret the man as making such factual assertion. Colborn does not even attempt to point to evidence that would support his conclusion by any standard, let alone clear, convincing standard, dooming his motion on the issue to failure. Fact alleged defamatory implication was reasonable, not overcome defendants, uncontradicted to the affidavits, they were unaware of such implication. Fourth, even if Colborn could somehow establish the implication he alleges, he cannot meet his burden of proof falsity. In other words, if the crux of Colborn's lawsuit and his MPSA and the MAM Act accuses him of planting evidence to frame Avery, then he has the burden of proof to not plant evidence to prevail on. Summary judgment. on the issue of falsity, but the only evidence Colborn points to on this issue is the falsity in his own testimony at Avery's murder trial, and he did not plant evidence. There is no more than what he did insufficient to show that MAM communicated a false statement or fact about him, particularly if MAM included Colborn's testimony denying he planted evidence. A plaintiff's self-serving testimony standing alone cannot entitle him to summary judgment on the issue where he has burden of proof. Burden of proof must show evidence. It's not one-sided that it must prevail in a matter of law, cleaned up. If such evidence was sufficient, every defamation plaintiff would be entitled to a summary judgment on the issue of materially falsity, because plaintiffs always deny that the thing defendants said about them is true. They must say that in order to state a claim. Yet plaintiffs rarely succeed in such efforts. Colborn has not cited a single case where a plaintiff established falsity in a matter of law. Contrary to Colborn's false contentions, MPSJ at 16, Netflix does not have to affirmatively show that Colborn planted evidence to defeat this motion. In fact, well, if Netflix was able to prove that he planted evidence, that would mean that his attorneys would be able to plant evidence, prove that he planted evidence too. So, yeah. This shit is getting stupid. But, even the point to contradict the facts are recorded because party opposing summary judgment does not have to refute factual propositions which should motivate bears in the burden of proof from the movement that are properly supported in the first instance. Because Colborn has failed to meet his burden of proof, provide evidence, and challenge statements alleged applications are false, otherwise actionable, his MPSJ must be denied. Colborn cannot prove Netflix distributed MAM with actual malice. Even if Colborn has set forth the standards he must meet to prevail in actual malice at the summary judgment stage, MPSJ would still be inadequate. Colborn's actual malice argument fails for two reasons. First, as explained, Colborn has failed to carry his burden and provide statements, and he puts the issue in applications that alleges that are false. There is no acknowledgement of falsity in the statement, false case in Louisiana. To recover defamation, a public official must prove statement's issue was false. Second, Colborn does not address how limited evidence he cites to support what he must clearly and convincingly prove that Netflix knew specific challenge statements and alleged implications were false or had a high degree of awareness that were probably false. To the contrary, not once in the MPSJ does Colborn assert, with or without evidence, that Netflix or any other defendant knew or had any awareness that anything at MAM would about Colborn was probably false. The failure alone dooms Colborn and MPSJ on the issue of actual malice. Instead, Colborn reveals a preposterous mischaracterization of the terminal case, St. Amant, and the cornerstone of the entire actual malice argument. Colborn asserts that St. Amant stands for a proposition that actual malice can be shown by reliance on sources that are unverified or anonymous. MPSJ 5, the actual malice can be found matter of law under actual St. Amant because of the evidence inherent basis of resources. MPSJ at 13. This is not what the Supreme Court said in the case, and Colborn's gross mischaracterization is the opposite of the law. Actual malice may be found, the Supreme Court said, where a story is fabricated by the defendant and the product of imagination or based while holding unverified anonymous telephone call. Well, like, the defense brought the theory forward that Colborn planted the key. Netflix and the producers were just there to document everything. So, actual malice must be found, Supreme Court said. A story of fabricated defendant, product of imagination, or based wholly on an unverified anonymous telephone call. The court did not say the quoting bias source was evidence of actual malice and will settle that bias. I wonder if they can get a subpoena to go inside the Manitowoc safe and see what the fuck is in there. Because we already know that they had files tucked away on Stephen Avery. And Michael Griesbach even states that in his book. So, shit's crazy. Did not show. The purported evidence to actual malice Colborn does cite notes by Netflix employees and one of the filmmakers do not even hint to acknowledge the awareness of false statements in fact about Colborn. Many reference notes undermine Colborn's argument. Most I lost my place there. Jesus Christ, where'd it go? Most considered evidence to actual malice news gathering would be severely chilled. The reported evidence actual malice to Colborn does cite note by Netflix employees and one of the filmmakers did not hint or acknowledge awareness of any false statements or the fact about Colborn. Many of the reference notes undermine Colborn's argument, and most of the note nothing to do with challenge statements at all. The notes mention only of the statements Colborn challenges while alluding to another. Neither shows that any changes was made to the statements, content, placement with the MAM as a result of Netflix suggestions. Colborn points to a note from Netflix that mentions that he has labeled the statement a statement by Avery's cousin Kim Ducat that she felt Manitowoc was not done with Avery when he was released from prison in 2003. I agree with that 100%. Colborn falsely asserts that the note suggested that filmmakers used Ducat's quote to impart or more explicit ending to an early episode and makes it clear that the next episode the cops are going to seek revenge. But the note does not suggest that the Ducat quote that they may or even changing this placement within this episode. See document 286, where it is remained in the final version. What's 286? There's so many fucking declaration there. Bruce Walker, Exhibit 1, Demo's deposition. There's Samura's deposition, Del Deo's deposition. Samura, Del Deo. Oh, they're just experts from their producers. Okay, we're on the final version that's on Netflix. They aren't even close to being done with. Meanwhile, the suggestion that the cops are going to seek revenge, which is nothing more than a summary of Avery's allegations at the murder trial, is no way indicates that the author knew or suspected that the false statement of fact is cited portion of Lisa Nishimura's deposition testimony. She really states that the document does appear to be a set of notes Netflix transmitted to the filmmakers. Nishimura especially says that she did not author the document, but she probably contributed. Colborn also refers to a statement in which one of the notes that seems very thin that Colborn not having specific knowledge about who called him, what the key to the case, referring to the jail call Colborn received around 95. Well, if Colborn did in fact do his job and pass it on like he says, Stephen Avery should have been out right away. They should have looked into it, but no, Kasurk and them all covered it up. Anyway, like even after they'd sat on his DNA results for how long before? Yeah, I'm gonna just read, otherwise I'm gonna get frustrated. Manitowoc County Sheriff's Office failure to follow up the jail call was close to the conspiracy sounds as I think you could find in the case. However, setting aside the Glenn statement is non-actual opinion, not simply opposition about the significance of the jail call. It's not about the truth of the falsity. No one disputes that the call occurred or that he's like just grasping at straws. I swear to God. Beyond these two examples, there's otherwise complete mismatch between 52 items that are subject to Colborn's motion of evidence or actual malice he says has. Without any evidence supporting his position, Colborn resorts to more false characterization of the notes. For example, Colborn cobbles together isolated phrases from two different sets of notes to assert that Netflix had some preconceived law enforcement conspiracy narrative. He cites a note that suggests providing them theme music for the baddies. Oh. But the note, does he even know what the theme music is? Because he claims he's never watched the whole documentary. And he also claims that the music from the documentary has caused him distress anytime he hears it. Suggestion from an entirely different set of notes. Documentary should have thriller atmospheric score. Does not refer to Colborn and says nothing about the truth or falsity. So he's complaining about the notes that Netflix was given to the producers to enhance. This shit is stupid. Common sense, Wisconsin law, music does not make assertions of. He's complaining about the music. Colborn says that another note shows defendants were actually actively looking for opportunities to use source material in such a way to elude the fact that cops may have planted something. Yeah, they planted the whole idea that Stephen Avery murdered Teresa Halbach. That's what they planted. That document, a page of notes from a large 2014 memo regarding episodes 1 through 4, actually states, is there anything we can use to clarify whether or not the cops had a warrant to search his property and allude to the fact that they have planted something when they were without permission? This note shows that opposition to actual malice. Here again, a Netflix employee was referring to the Avery's allegations at trial of evidence planting. The Netflix employee sought additional factual information to clarify for the viewers whether the searches that Avery contended were tainted had been conducted under a lawful warrant, and stating the officers may have planted something. Well, little side note. On the morning of the 7th, I've said this before, they were talking about wrapping up the investigation and turning the property back over to the family. Then Cuffs Road happens. Then they reapply for another search warrant, which only lasted a few days because they had to reapply again for another search warrant. But makes you wonder. Colborn also points to Netflix endorsing using Avery's father's statement. They framed an innocent man just like they did 20 years ago as a cliffhanger. At 13, citing NFX Colborn 0001-1981. I don't know what the fuck that is. Whether a statement should be a cliffhanger is not legally significant. Regardless, in the final version of MAM, the statement is not used to cliffhanger in its episode 2 episode. Alan Avery's quote is included in 1349-14-4 episode 3. Not only does the note fail to show the acknowledgement of falsity, it illustrates that notes were merely suggestions and did not necessarily result in changes to the finished series. The NPSJ also refers to notes that Colborn says how to desire to portray Avery in a positive light. They are irrelevant to the issue of the actual malice because so he has a problem with the way they made Stephen Avery look. That has nothing to do with you, Andrew Colborn. Whether they knew anything Colborn was false. Finally, the motion refers to an email from Filmmaker Mort Demos that was not sent to me, any member of Netflix team responsible for MAM, about images used in the trailer. Advertisement for the series, MPSJ at 14. The trailer is not an issue in the case. Colborn has never mentioned anything or other pleadings and does not include his 52 challenge statements. The email has not probated value here and has nothing to do with the falsity of any event. MPSJ simply does not identify any evidence record from the reasonable jury could not find Netflix distributed MAM with knowledge of awareness that it contained falsehoods and Colborn, much less be clear convincing evidence. If accepted, Colborn's arguments would upend more than a century of settled defamation law. Colborn's fundamental misrepresentations about the First Amendment and defamation law are so jarring as to worth reflecting on, which would mean accept them. Under Colborn's theory, because he denied planting evidence during his trial testimony and because the jury convicted Avery, the end of the story. The verdict vindicated him and marked the moment the public was no longer permitted to dispute Avery's guilt. Law enforcement conducted a possibility of miscarriage of justice had occurred. In other words, under Colborn's testimony, MAM could not safely release to the public until Avery's post-conviction appellate attorney Kathleen Dunner actually succeeds and exonerated him. It would mean that no one could safely have debated whether Avery was wrongfully convicted in 1985 or accused the public officials involved in conviction and misconduct incompetence until Avery's exoneration. But of course, documentaries consider issues like this all the time without concern for liability. As one example, consider a serial podcast which highlighted questions of the inconsistencies of conviction of Adam Syed. The podcast was released while Syed was sat in prison for a 1999 killing, and questions about the verdict podcast explored the results in the Syed's vacated conviction in September and the prosecution's request for law enforcement prosecuting misconduct. Prosecutors recently dropped all charges against Syed, declining to retry him. Under Colborn theory, however, publication of the podcast prior to Syed's release would have been false and defamatory, leading to the absurd result that no publisher could, without fear of liability, uncover a report potentially miscarriage of justice, which such investigation reports matters most of all. I think they're just all pissed because Netflix took on the documentary and exposed all the corruption that's taking place in fucking Manitowoc and continues to take place. I mean, you got Ricky Hostetler, that's unsolved, which is some bullshit. We all know that. Well, we're all pretty sure of what happened and why it was covered up. Closer to home, it would mean that because Kyle Rittenhouse was acquitted, publication of photos like this, which merely reflect one side of a raging debate and matter of intense public intent concern, some are defamatory. It cannot be a law, unfortunately, does not do the overlapping common law and constitutional doctrines discussed above. The Seventh Circuit observed recently the Wisconsin Supreme Court has long recognized the value of legal systems and reports about controversial cases holding to the public. Need to know whether the court doesn't sense it cannot eligibly report without stating the charges issued upon what the court's action is based. The latter may be reported also, although an incidental result of the fact that defamatory charges against some individual becomes public to his injury. Colborn, in essence, asked the court to rewrite more than a century of Wisconsin defamation law, prohibit public discussion, allegations made by losing side and consented to court proceedings. The public would lower should be prevail. Conclusion: for all the foregoing reasons, Netflix respectfully requests that the court deny plaintiff's motion for partial summary judgment. Okay, that was document 307. 308, appendix Netflix in opposition to plaintiff's motion for partial summary judgment. Then we got a counter proposed finding for fact by Netflix, declaration of Leader Walker. Alright, I'm going to stop here on 307 because I got something to do. So, see y'all in a little bit. But it's getting interesting. For sure. Y'all have a good day, and I'll see y'all next time.